As well as the standard fair use policy, this video is protected under the Treaty of Peace and Friendship 1787.
Moors are awake. We are taking our place on this planet.
Numbers 21 through 24, People versus Daniel Grady L. and Shatina Grady L. 21513 FH and 21514 FH.
Are we going to do both of these together? I mean, they're the same motions from the people. They have slightly different fact patterns, and they have two different lawyers. So whatever you guys want to do, but what do you want to do?
Wait a second. Let me get this straight. We have two Moorish sovereign citizens showing up to court, and they both have lawyers? Wow. Other Moorish sovereign citizens out there are not going to respect these two. This should be interesting.
There's no objection from Mrs. Grady L., Your Honor, to do them both together. It makes sense, I think.
Yes, Probia Star on behalf of Mr. Daniel Grady L. Yeah, no objection to, doing this all together.
All right. And Mr. and Mrs. Grady L., can you hear us?
That's fine.
Yes.
All right. So let's start with, let me get the attorney appearances first. So Ms. Palapu, is this your appearance today? All right.
Yes, Your Honor. Good afternoon. Melissa Palapu on behalf of the people.
All right. And we have Mr. Starr's appearance. Mr. Amadeo, your appearance.
Good afternoon, Your Honor. William Amadeo, P76194, on behalf of Shatina Grady L. We both appear via Zoom and waive a right to be present in person. And Judge, I do think Prosecutor Wint's on as well on this matter.
Thanks, Mr.
Oh, yes.
Amadeo.
Ms. Tucker is here. I'm sorry. Yes.
That's okay, Your Honor. Good afternoon, Your Honor. Assistant Attorney General Yasmin Tucker appeared on behalf of the people.
All right. Ms. Grady L., tell us your name for the record.
My appellation is Shatina Grady L.
Okay. And Mr. Grady L., do you want to tell us your name for the record?
My appellation is Daniel Grady L.
Okay. Okay, I'll bite. That's fine with me. Appellation is a little unusual, but I'll go with it. So,
An appellation is definitely very unusual. And when you hear someone say they have an appellation, you can bet your bottom dollar that they are Moorish sovereign citizens. When they say, I don't have a name, I have an appellation, they most definitely are Moorish sovereign citizens. And it's funny how the judge is just playing along. One thing that I have noticed throughout all of the court hearings that I've seen with Moorish sovereign citizens in them, most judges are very respectful to these guys. So I don't know why they hate this country so much, because they're always dealt with much respect, even though we know their beliefs are wacko and out of this world.
all right, today is the date and time set for the people's motions to admit, acts of prior motion, more 404B motions. So that's in the biz. Notice and a motion in limine to admit prior acts. I've had a chance to review the motions and the responses and the briefs. I'm happy to hear from either Ms. Palapu or Ms. Tucker. Highlights, again, you don't need to repeat, but I'm happy to hear your oral argument, and then I'll hear a response from Mr. Amadeo and from Mr. Starr. Okay?
Thank you, Your Honor. Your Honor, I'm not going to go back and repeat everything that I had previously written. You did have all the facts regarding the prior conduct, and you have my motion with all of the law. I would just like to make a little response in regards to the defendant's motions themselves. In regards to Mr. Daniel Gradiel's motion response, I just wanted to also state that during that response, there was no statement of defendant's theory of the case in regarding in order to back his argument that these acts would not be relevant. In order to say that, you would need to state his theory of case to show that they are not relevant. And in fact, that there was no statement or theory of the case that was provided. I would just like to reiterate that the people do intend to admit this evidence to show that there was an absence of mistake or confusion as to what was occurring at the scene, or confusion of the officer's commands, that there was to demonstrate the intention to obstruct, which goes with the absence of the mistake or the confusion, and to rebut any argument of the defense to the contrary of those statements. In regards to my response to Ms. Shatina Grady-L's response.
So let me interrupt.
Yeah.
So, while we're on Mr. Grady-L's
Sure.
motion, I just want to be clear that the prior incident that you are seeking to have admitted is that 2019 incident, correct?
Excuse me, Your Honor, but I must interject. It seems the defendants have disappeared. Where are the defendants?
Yes,
Because there's a slight difference between the two defendants. One is the 29. Mr. Grady-L is singularly that 2019 incident, while Ms. Grady-L includes both the 2019 incident plus another one. Correct? I just
yes.
want to. Okay.
Yeah. Yes,
All right.
Your Honor. It would just be that one incident for Mr.
So
Grady.
let's do this one at a time. So let's go ahead and I'll hear from Mr. Starr. If you wish to respond to what the prosecutor has just stated on the record or anything else, you may do so. But I have reviewed everything. So go ahead.
Yeah. So first is to the my alleged facts. It's clear, and I do provide some basis here as to my client and why, if the 404B were allowed to come in, it would basically strip away what I'm alleging in my facts as to what occurred. But to put it simply and briefly, Your Honor, normally with the 404B motion, you're talking about a prior crime, a prior act, right? Here in this situation, from reading plaintiff's motion, they're not only speaking about a prior act, but also to defendants' alleged affiliation with an organization, and basically saying this affiliation with this organization is the reason why he is conforming to these responses with the police. 404B is plainly states that's not allowed. Evidence of other crimes, wrongs, or acts is not admissible to prove character of a person in order to show action in conformity therewith. They're speaking about things that are character evidence. They're saying, hey, he's acting in regards to how this Moor organization acts. But then on top of that,
Can I interrupt you,
Yes,
Mr. Starr? Let me interrupt you. I don't know why your client or Mr. Amadeo's client turned their video off, but this is the best we got with Zoom, so you can't elect to turn your video off during a hearing. Go ahead, sir.
I didn't turn my video off, Judge.
No, your client.
Oh, I apologize. I didn't know that.
Okay, go ahead, Mr. Starr.
Where was I? Oh yes, but then on top of that, they don't provide any type of substance, any type of materials, any type of literature or anything of that nature to show that yes, this organization does act in this regard when it comes to law enforcement. This is an assumption.
Excuse me, sir, but all you have to do is go to YouTube University, type in Truth Science 151, and I have countless videos of people that are part of your client's organization acting a fool with law enforcement because they are Moorish sovereign citizens, and they believe that they are above the law, and they believe that this is their land, and they believe that they're not citizens to the United States. This is why they act the way they act in regards to when they come in contact with law enforcement. Just go to YouTube and you will see it for yourself. I rest my case, Your Honor.
As I cited in one of the cases, this is this is character evidence masquerading as one of the exceptions. This is purely character evidence, and if it were to be omitted, this would violate my client's due process right to a fair trial, because it shifts the focus from the events of that night to, well, what are their beliefs, right? That's what we're talking about. What are their beliefs? Which, again, plaintiffs are assuming their beliefs.
All right, Ms. Peliku or Ms. Tucker, anything to respond to that?
Your Honor, I would just indicate that my motion has absolutely nothing to do with their political beliefs, or I'm not really sure how to classify the organization, but that honestly, I believe they probably will bring that up themselves in trial. But that is not the focus of the argument. The argument is solely based upon that conduct that the police report was attached.
Okay. All right. And then since we have kind of argued that issue, I'm going to shift it now to Ms. Grady L. And again, there were two, I believe, there were two incidences in that question. So is there anything else you wish to comment there?
Your Honor, I'll just state the same thing, that the response to my motion did not provide any theory of the case or any explanation as to why this information would not be relevant. The people intend to utilize this information for the same purpose as previously stated, to show that there was an absence of mistake or confusion, and to show that there was the intention to obstruct the officers when going to that scene, and to rebut any argument from the defense to the contrary.
Okay. And Mr. Amadeo, any specific response for today's hearing?
Your Honor, you read our reply, and so did your staff, and I'll rest on that. I'll just add a couple things briefly. I don't know what the Attorney General means when there's no theory. This squarely rests on the Denson case. There's no striking similarity. In fact, the only similarity, Your Honor, is that my client's been a victim from 2 police agencies. I'll leave it at that. Thank you.
All right. So it's actually kind of hard for me to articulate exactly where I'm going with this. You're going to have to bear with me. In gross summary, I've reviewed all of the case law and the relevant rules of evidence and court rules on this issue. And so what the people are seeking to admit is evidence under MRE 404B that would allow a jury to hear prior criminal action or activity to essentially to show intent, absence of mistake or accident, or a system doing an act. It's somewhat limited to those purposes, and so I am cognizant both of Mr. Starr and Mr. Amadeo's arguments, but in looking at and that's why I was kind of trying to articulate the particulars of the differences between the two. So the 2 defendants share one incident that the people are seeking to admit prior evidence on, that being the March 2019 incident, I believe, in the parking lot. And Mr. Amadeo, you bring up the question of striking similarity. And actually, I do find that there is striking similarity in what happened in that 2019 incident, as well as what is alleged in this case. I will note for the record that in the 2019 incident, there was a refusal on the part of the defendants to identify themselves, provide documentation. There was a refusal to cooperate with the police agency. Eerily similar family arriving and surrounding and videotaping the situation, and that allegedly in this case, in the current case, but what I believe was confirmed in the earlier case was the police had to act to not only break windows but physically remove the defendants.
Wow. Did you guys just hear that? The police had to break these Moorish sovereign citizens' window to get them out of the car. Boy, do I wish I got my hands on that footage. That would be a lovely thing to view. These Moorish sovereign citizens do not respect the law, which is why officers are constantly having to break their windows to get them out of their personal conveyances.
So I do find that that the evidence for March 2019, that incident in the Walmart parking lot, is admissible under 404B. It is not the finding in my analysis of this that it is unduly prejudicial. I believe there are methods the defense can cure any potential undue prejudice with both jury instructions regarding the 404B evidence, as well as, yet to be determined examination and cross-examination of witnesses. So I believe that the defense has the mechanism to either cure or mitigate the potential for undue prejudice in this. I will grant the people's motion as to both defendants on the 2019, I'm just going to call it the Walmart parking lot incident. The other interesting piece, though, is looking at Ms. Grady L's other instance. And so the people are seeking to admit evidence from a December 2019 high-speed chase.
Say what?
And while there are some similarities between the kind of the end result of that chase, I do find that under the Benson case that there is not a striking similarity, and that I am going to deny the people's motion as to that incident. So the ruling of the court, and so I will sign that order upon submission. Thank you.
Thank you, Your Honor. Have a good day.
Thank you. Well, hold on one second. Thank you, Your Honor.
Hold on one second.
Thanks.
Is this also a pretrial or just these motion hearings?
I thought it was also a pretrial.
I know. Hold on. Before I let you go,
Yeah.
Settle down. Let's get to my docket. All right, so we do have pretrials in both of these matters. I will tell both counsel that so you understand this, that I don't have fingerprints in either case. And, we can't continue. I don't know if there's going to be a trial in this matter. I don't know if there's going to be a plea in this matter, but I'm going to order that the fingerprints be taken care of before the next event, whether it's another pretrial, a final pretrial, or whatever that is. Otherwise, I'm going to need to remand your clients to get those prints done. So I'm just reporting that to you. I'm not going to remand them. That's not my intention. But just so that you know that we have to have the fingerprints done. Okay?
And, Your Honor, I'll get on top of that, but I believed when I called the sheriff's department, they were done, denied the arrest. I think they've been done another time. If they're not in your file,
Mr. Amadeo, this is a bit of a head scratcher. It's true. But the fact is everybody gets fingerprinted when they're arrested, but somehow the fingerprints don't get attached to the court file. And we can't proceed without the fingerprints being appropriately attached. So there's a fingerprint order. They can either go get re-fingerprinted, or you can figure out a way to get the prints from the sheriff's department into the court file, and we can do it. So you believe me, you're not the only one to say that. But I'm just letting you know we don't have them. So that's kind of where we are. And so I'm not going to set another event for next week. I'm not saying I'm going to remand your clients in a week, but what I'm just saying is we got to get that done. So what do you think, counsel, that the next step in this trial is? These are 21 cases. So we're at pretrial status, but my next step would be to set a final pretrial and a trial date. So is that where we are, or is there further activity that needs to happen?
We have some motions to file, Your Honor, but we could certainly do that before whatever your trial date is and get a date from your court. If we want to set a trial date for maybe March, I don't know what your docket is, Judge.
I don't know if March is kind of a random and arbitrary month, but it would certainly be in 2023. So January is a civil month, so it's as likely as not we might set we could set a trial date for late February, early March. That's fine. We'll do a final pretrial end of January, early February. Any motions obviously would need to be filed and heard on or before that final pretrial date. Okay.
And then, Your Honor, I just wanted to put the offers on the record if I could.
Sure, go ahead.
So I just got these offers, so I just emailed them to both defense counsels just like a moment before the hearing started. So they have not had time to process them or anything.
Okay.
But I just wanted to make sure that they were on the record.
Yep.
As for Mrs. Shatina Grady L., the offer for her is to plead to count 1, which is the R&O causing injury, and we would dismiss the remaining counts. I believe her guidelines would be 12 to 24. We would leave the sentencing in the court's discretion. As to Mr. Grady L., the offer would be to plead to a reduced count 1 to an attempted R&O, which would be a 1-year misdemeanor, and we would dismiss the remaining charge, and we would again leave sentencing in the court's discretion.
Okay. Counsel, you heard that, and you'll have a chance to discuss that with your clients, correct?
Correct, Your Honor.
Yeah, I
All right.
received the prosecutor's email on that.
All right. So let's go ahead and set a final pretrial date for toward the end of January.
Let's do January 30th for final pretrial.
Okay, and then trial date would be end of February, early March kind of thing.
We could do February 27th or March 6th.
March
Any
6th will
preference?
work better for me.
All right.
Could we go
March
1 week
6th?
further? I'm in trial on March 6th and February 27th, Your Honor. I apologize. But
Okay.
March
All right. So
13th.
next one, the 13th, March 13th.
Yes.
How does that
that would
work?
work well. That works for me, Judge, if that's acceptable.
That
All
works
right.
for the people.
All right. Good. So we'll set the trial date then for March 13th. That's 8:30 a.m. Monday for jury selection. And we will see you at the final pretrial, or if there are other motions to be filed. You don't have to wait till that final pretrial date, but that's the next court event. Okay. So I need to have the prints done by the final pretrial. And I did just check while we were on the hearing. They weren't printed. The sheriff's department does not have fingerprints for them. So that's going to need to happen.
Okay.
All right.
I was told differently. I apologize, but I'll get on top of that.
No,
Judge.
I'm not, I wasn't there, but I'm just letting you know what we know. So, okay. Thank you.
All right, thank you, Your Honor.
Yep.
Do you see how much smoother these court hearings go when individuals actually allow themselves to be represented by lawyers? Everything went so smooth. I actually applaud these two Moorish sovereign citizens for letting their lawyers handle everything. There was no silly objections or, I want to represent myself, and then just spewing random cases that have nothing to do with anything. So these two Moorish sovereign citizens actually have a fair chance of beating whatever charges it is that they're fighting. So this is a lesson to any other Moorish sovereign citizen who gets into any type of trouble with law enforcement. Do not represent yourself. Let a licensed attorney represent you. And as you can see, things go much smoother. It's way less of a headache for you and the judge and everybody involved, for that matter.